right, so we are going to get started, and we are going to be talking today about the exclusive right to buy, the buyer's agency contract. Second Monday of the month, typically what we do is the buyer agency. Next week we'll go into the purchase and sale, and then the fourth Monday we will go into kind of a general discussion. So I'm going to go ahead and share my screen. We can start talking about that. And basically how this goes is I walk through kind of what the document states, and then typically what that does is it gives me some reminders about what we're seeing in the market, what I'm seeing come up as far as broker issues and everything like that. So what you should see right now is the exclusive right to buy buyer agency contract. Is that what you're seeing? Okay.
Yes.
I will also very quickly drop it in the chat. For you to download. So you should be able to download it as well. All right. So basically the agency agreement is between the contact who is the buyer and then the broker in charge of Keller Williams Realty. So you would put in there the contract, is between whoever the buyer is, and then on there you'll have Keller Williams Realty as an exclusive agent. Basically it's going to go through, it says by hiring this person, you're kind of going to go through the terms that we'll talk about in section 2, and then we'll go through the duties of which each person in the contract has. The good thing about getting to know this contract is it really kind of helps you walk through your duties as an agent. It also helps you uncover certain areas to set some expectations for buyers that you get under contract with. So the purpose of this agency is to purchase or lease real property, which may include items of personal property described as below. So in this area, you don't want to be too specific where it kind of rules you out of certain areas. However, it doesn't hurt to be specific to, say, a county or something like that. A lot of times if a buyer is looking in the area, but they're also looking at Myrtle Beach, or they're looking down at Hilton Head, you may have the opportunity to put in here, your general description could be a single family home, approximate price range, and then the general location could be, Greater Charleston, Dorchester, Berkeley. You just want to put some terms in here. 9 times out of 10, it is going to be residential, unless, of course, you do have someone who's looking for vacant land. If you do get into the commercial side of things, obviously at that point, you could address that as well. But 9 times out of 10, it will be for residential. So we dive into section 3 here, which is basically describing the broker's duties. This is what I will do as your agent here. I provide the buyer meaningful explanation of agency, which, by the way, should have already been done prior to signing this or filling it out, right? Use the broker's professional real estate knowledge and skills to represent the buyer in a diligent and effective manner to locate property which is available for purchase or lease to the suitable buyer. In addition to that, I'm not representing the seller. The broker shall represent solely the interest of the buyer in all negotiations for the acquisition of real property, and repudiate any agency or sub-agency relationship with the seller or the company representing the seller, and shall not claim the sub-agency compensation offered to a selling broker. What this basically means is saying that I am representing you in this. I'm not going into it representing the seller and then you're a sub-agency. This is separate from dual agency or designated agency, which we'll talk about later. But this is basically stating we have an agency relationship and I'm getting paid by the listing broker because of our relationship. If the broker represents the seller as well as the buyer, i.e. disclose dual agency, the broker shall not disclose the buyer's information obtained within the confidentiality and trust of the fiduciary relationship with the seller, nor disclose to the seller information similarly obtained from the buyer without the consent of the party that would be adversely affected by the disclosure. So basically what this is saying is, should we get into a situation where I do represent, or Keller Williams represents the seller, that means we'd be going into disclosed dual agency, would be designated agency if you're not the agent. And this is basically stating that I'm not going to share information that was obtained confidentially that would adversely affect you as my buyer client. The broker may represent other buyers who may be interested in the same property as the broker. As the buyer. This is an important thing to point out in your buyer agency or your buyer consultation. It says, hey, there may be a time where I would represent 2 separate buyers that are interested in the same home. And then it says, upon the termination or completion of this agreement, broker shall keep confidential all information received during the course of this agreement, which was made confidential by written request. So again, the confidentiality extends the expiration or termination of this contract. Okay. Broker represents that the broker is licensed under the laws in South Carolina. So basically, I promise you that I am actually licensed under the law. And I will use my best efforts as the agent to locate properties described above, negotiate acceptance of an offer by the buyer to purchase the property. During the term of this contract, I'll give buyer information describing and identifying properties that appear to brokers to substantially meet the conditions that is set forth again above. So again, I'm going to put forth my best effort in order to represent you, find the property, negotiate the terms that you want in the property, and then be able at that point to have you get that property. I've represented you in doing so. All right, so the buyer's duties. Now, this is a good one to be able to explain because, again, you may not go read through the paragraph right here to explain to them, but this would be good to set it up kind of as an expectations conversation. So, Mr. and Mrs. Buyer, by getting into business with me, this is kind of what you can expect of me, which was everything we kind of listed in paragraph 3. And this is what I would hope to be able to expect with you. The first one is to work exclusively with me during the term of this agreement. Right. So basically, and there's another paragraph that will come up where they basically state that they're not currently working with any other agents, but you're telling them that you're asking them that during this period, they will exclusively only be working with you to search for properties. They'll do this by viewing any properties, previewing, et cetera, only with me or designate a representative that is not with another real estate broker. So in the event Sarah and I get into a relationship, I'm the buyer, she's the agent. I'm basically saying I'm going to work with Sarah, or if Sarah's out of town or working with another buyer, Sarah could also have Christy come in and, show the property because Christy's also licensed with the same brokerage. Exclusively allowing the broker or salesperson to identify property, negotiate for buyer, and otherwise represent the buyer. Now, one of the things you may want to say in your buyer presentation is to be, listen, I'm going to send you properties. And I would like to be the one that helps you find it. However, if you are searching on other sites, if you are using the Zillow app or my app or whatever website that is fine. Should you find any properties that I have not yet sent to you or for whatever reason didn't come from me, just forward them my way and I'll make sure I get all the information for you. So go ahead and set it up in a conversation that you may not be, excuse me, the specific person from which the house comes that they're looking for. Right, so this is where you tend to open that up a little bit, that if they want to go searching for the home and other means, they can, but just to make sure that they send that information to you, which spills over into section 3, which is refer to broker all inquiries received from any and all other real estate broker or affiliated licensee. So if you do have a broker that follows up with you because you checked in on their website or you met them at an open house, that's completely fine. If they do follow up with you saying they have a potential property for you, just contact me and I'll make sure that I communicate with them and get you into that property. Hold the broker harmless from liability as a result from incomplete and inaccurate information provided to the broker by the buyer or the seller. Basically, if someone gives us bad information, you're not going to hold me accountable for it. Hold the broker harmless from liability as a result of seller's failure to provide a complete property condition disclosure statement. And indemnify the broker against all claims, damages, losses, expenses, or liabilities arising from the handling of earnest money by anyone other than the broker. So all of these, again, are just saying, if in the event something comes up, I'm going to do everything I can to protect you. We're going to make sure that the property condition disclosure is filled out, but we never know that's fully accurate, which is why we get home inspections, right? We get everything done to verify the information that's been given to us. Second part is to assist the broker and affiliated licensees in the process of identifying, negotiating contract purchase lease or otherwise. They're going to do this by providing the broker with reliable information, including your financial information, right? Anything basically that I deem necessary that's going to help in the process of this agreement, that you'll provide that with me. So if we're going in for an offer, I would like to have the financial information, meaning you're approved to finance the property. We don't have to tell them for how much, but we do need to be able to tell them that you're able to finance this specific property. You'll provide that information for me. You'll also, buyer will make themselves available to meet with broker to see properties in order that the broker will be able to perform the promises of this engagement. So Mr. and Mrs. Buyer, in this market now, we just need to be able to set up times to go out preview properties and you can meet me there. If not, we may have another arrangement where either if you have somebody that's looking with you, or if you're going to FaceTime or video or anything like that, you want to make sure that you're working with them so they understand what it is that you're looking for, or what they understand that you're looking for them and you understand what you're looking for them. that's a big process of when you're showing houses, of being there with the buyer so you can start to work with them and understand what it is they're looking for. All right. Section C, provide the broker and its licensees general nature, location requirements of what properties they're looking for, what price range, terms, and other things that they're looking for. And then also authorize the the buyer's attorney and settlement agent to furnish the broker copies of the final settlement statement. Again, this isn't part of the contract you're necessarily going to go through and list, hey, here are the things that you're going to do for me, Mr. Buyer. Yet it is a good checklist to make sure you're covering all of this. Like, understand that the couple that jump out in this section, to be honest with you, I'm going to drop this contract back in there too. If you came in a little bit late, the one we're covering, I've put into the chat box. You want to make sure you cover a couple things. And in this section, some of the things that I'm seeing kind of come up a little bit is, one, making sure you're setting the proper expectation for your buyers that you will need financial information to have an aggressive offer. And just make sure they understand that up front. You don't have to send your full, financial, position or anything like that. Yet, if you are paying cash, they're going to want proof of funds. If you are getting a loan, they're going to want to know you've gone through the process and it can be a solid buyer. The second thing would be is in this one about authorizing the attorneys to furnish copies of the settlement agreement. Again, I am going to get final copies of the settlement agreement, so I want to make sure you're aware of that. And then lastly, the one part that also tends to come up is the I just drew a blank. Earnest money. Understand that earnest money is held by a third party. It's not held by us. So if there is a dispute, and there is a part on earnest money we're going to talk about a little bit later, but if there is a dispute on the earnest money, that this does have to be worked out. It is held by a third party. We don't have any control over that being released. So just important thing to explain to the buyers so they understand the process. All right, so let's jump back in. So going into section 5, and this is kind of the part that gets a little bit squirrely, just in understanding how it works. A couple different ways that you're paid as the broker. So this is compensation of the broker. Broker's fees will deemed earned when the buyer is under contract to purchase any property presented by the broker or negotiated by the buyer. This fee will be due and payable at closing or upon the buyer's default. Buyer does default, the total compensation that would have been due the broker will be due and payable immediately in cash from the buyer. I can safely say that in the entire time I've ever been a broker, I've never seen an agent go through with that. If the buyer defaults, I haven't seen too many actually take the buyer to court and get their brokerage fee. So it hasn't happened, but I haven't seen it happen. So 2 ways they're paid. The first one, and then under each one, there are 2 subcategories. The first one is a brokerage fee. Brokerage fee option 2 is typically what 90% of us use. So I'm going to go to option 2 first because it's the simplest one. It basically says that the broker shall obtain payment of the brokerage fee out of the transaction, meaning they're going to be paid by the cooperating broker as stated in the MLS or as agreed by the broker or cooperating broker. Meaning if, let's say, you get a property that's not in the MLS, so you negotiate a compensation agreement at that point in time, or as agreed upon by the broker and the seller in a for sale by owner transaction. Buyer shall not be responsible for paying the brokerage fee. So basically what that means is you're going to take the risk that you're only going to get paid if the seller or the listing agent is offering you money and it goes to closing. Now, there's the reason it breaks it down into the 2 separate ones. Something to keep in mind is if a home is not in the MLS, you have no contractual protection as the buyer's agent to be paid. So in a situation, let's say you've got a buyer, they see on their Facebook page, an agent says, hey, coming soon, this home's coming to the neighborhood, it's going to hit the market, tomorrow. If it is not in the MLS and your buyer writes an offer on it, you're not protected in your commission. So you would want to get a compensation agreement. Okay. Now, if it is in the MLS and it's in the coming soon status or something like that, then you're protected. The MLS is a unilateral promise for you to pay the commission that's offered in there. So just keep that in mind. If you do have a situation where it's not currently in the MLS, you would need a compensation agreement. Same thing would apply in option 2 as it relates to the for sale by owner. You would want a compensation agreement. This one would be a little bit different because this compensation agreement with the for sale by owner would be between the seller and you and Keller Williams as the buyer brokerage versus it being between the listing agency and Keller Williams as the buyer's agency. Okay. Now, the other way that a brokerage fee is paid, and we're starting to see this one become a little bit more used is this option 1, where the buyer shall pay a brokerage fee which is the greater of blank dollars or blank percentage. So for the example, I'm going to use 3. So say they filled this out and you said that the buyer shall pay a brokerage fee which is greater of NA or 3% of the purchase or total lease price of the property purchased by or including for sale by owner properties. If within blank days, let's just put 30 for this, after the expiration of this contract, the buyer purchases or leases any of the properties for which the broker has negotiated during this term, the buyer will pay the brokerage fee stated above. This is the important part, really the most pertinent part of this, which states the broker shall use their best efforts to obtain the payment of the brokerage fee out of the transaction, but the buyer shall have the obligation to pay the broker the brokerage fee set forth in this contract if broker cannot obtain payment of such fee out of the transaction. Any fees paid by the seller or seller's agent should be credited against the brokerage fee. Okay, so here's what this means. If you take the example of 3%, so you put 3% in there. This is basically saying that if you work with me, Mr. and Mrs. Buyer, I'm going to do everything I can to get at least 3% out of the transaction. However, if I do not, you're promising to make up the difference. So if I show a property that's listed at 2.5%, you'll pay the additional 0.5%. If a for sale by owner only agrees to pay me 2%, you'll pay the additional 1%. You get the gist. A couple things that this is causing to happen is if that's the case, and you're a buyer, you're a buyer's agent, and you have a buyer that's looking at 2 properties that for the most part are identical properties. One of them is offering to pay you 3%, and one of them is offering to pay you 2.5%. Well, if you have option 1 checked here, then the property that's only offering 2.5% may cost your buyer more money to buy because they're going to have to pay the difference than they would in the one that's 3%. So what that's causing is a lot of times buyer's agents are reaching out to the listing agent to say, hey, I've got a buyer who's looking and our buyer agency they'll pay 3%. Are you or the seller willing to pay 3% on this? Just want to know that before we present an offer or see the property, just so I can explain to my buyer whether or not they'll have to make up the difference in this. There's nothing wrong with having that conversation. So if you're a listing agent and you're offering out 2.5 and you get that call, don't freak out. The only thing that makes it wrong is if you, as the buyer's agent, say that you're not going to show the property because it's not getting the commission, not offering the commission that you want. That's where you get into hot water. But there is a lot to be said for picking up the phone, calling the listing agent, say, hey, I noticed you're offering out 2%, or you're only offering out 2.5%. Are you able to go to 3%? I just want to make sure I know this, because if my buyer chooses this house, it is just going to cost them, they may have to cover the difference on the commission. Yeah, just something to keep in mind. I'm not advocating one way or the other. It's probably 80% on option 2 right now and 20% on option 1 on how the brokerage fee is paid. But we are starting to see more and more of it. And I think we will start to see it lean more towards option 1 over time, particularly as NAR starts to crack down on the transparency of how much buyer's agents are being paid in a transaction. I think we're going to start to see that be more and more prevalent, and we'll probably start to lean more towards buyers actually paying for the buyer's agent more so than they have before. I don't know when that's going to happen. Probably not anytime in the next couple of years, but we'll probably start going that way. All right, questions so far on the brokerage fee? Perfect. All right, so then there's other. You basically have 2 ways that you can be paid outside of the brokerage fee. First one is a retainer fee. A retainer fee is basically a fee. Let's just say for the example, it's $1,000 due and payable upon the signing of this contract. And then it shall or shall not be credited against the brokerage fee. So let's just go into the same situation. Sarah and I get into a relationship. I'm the buyer. She's the buyer's agent. She has a retainer fee. I give a check for $1,000 and I make out to Keller Williams Realty, paid to her at the signing of this. Okay, so she's paid this regardless. And then that can be credited or not credited against the final brokerage fee that Sarah earns when she gets to closing, right? Most of the time it's not credited against it, it's just an addition to. It's totally up to you on how you'd want to do it. If it's credited against it, just keep in mind at that point, you'd have to then rebate that retainer fee back to the buyer on the closing statement, which is fine. Just want to make sure you communicate that ahead of time in case the lender wants it worded a certain way. Then there's a service fee, which the seller shall pay a broker a service fee of blank that should be paid within blank calendar days on whether or not the buyer purchases the property. So the service fee is basically just a fee. It's not much different from a retainer other than it's not necessarily paid right now at the signing of this. and it is not contingent on whether or not they show them houses or find them houses. This is a fee that they're paying regardless of what happens. The service fee shall be the only fee due to the broker, or it shall be credited again. You can do a couple different options. You make the fee only fee due to the broker and buyer under the terms of this, from the buyer under the terms of this contract. It means there's no additional fee that would be collected. The service fee shall be credited against the brokerage fee described above and shall be kept by broker where whether or not a brokerage fee is earned, kind of the same thing as a retainer. Or the service fee shall be credited against the brokerage fee described above and shall be kept by broker whether or not the brokerage fee is earned, unless the buyer enters into a purchase or sale agreement. In the event the buyer enters into a purchase and sale agreement, the buyer and broker agree that the above service fee will be credited against the broker fee in subsection A above. So basically what this last one says, if we're going to do it, then I'm actually going to credit this towards your buyer's agency or towards the fee that I would get up here above, which would then allow me to credit you back at closing. Okay, so the service fee is paid for you to have made out to you whether or not you close, and then if it does close, you can be credited on there. We typically, if we see anybody doing it, they're doing it in the form of a retainer fee, which basically says, hey, I'm going to collect $1,000 up front. That's a fee that I get on there, and that's the fee I get for driving you around, that sort of thing. We're not seeing too many of these happen in this market right now. I think as time goes on, we'll see more and more of them, particularly as we have buyers that are shopping different locations. I think sometimes agents are going to be, they're going to tend to want to be compensated for their time, particularly if there's a buyer that's just kind of coming around for a joyride, for lack of a better way to put it. All right, questions so far? All right, I'll keep going. Section 7, the terms of the agency. So again, this is up to you. There's no standard amount in there. I always have my agency agreements terminate at the same time, either the end of June or the end of December, 2 times a year. That's what it is. So if I had a buyer that I was signing on right now, I'd have it go through June of next year, simply so I don't have to worry about who's expiring on what day. Would do the same thing with listing agreements. Again, that's a personal preference from an operational organization kind of thing. It's completely up to you. Section 7, this is where they consent to disclose dual agency or designated agency. First thing is, this says the buyer acknowledges receiving, which is past tense. So hopefully you've explained it to them prior to getting here. Otherwise, you're going to have to backtrack a little bit. Receiving an explanation of the types of agency relationships that are offered by a brokerage in South Carolina. And the South Carolina Disclosure of Real Estate Brokerages from its first practical opportunity, which is substantive, yeah. Contact occurred between the buyer and the broker. Now, again, there's a lot of questions on when this should be. If it's a sign call, they're asking a few questions. No, probably not. Then they want to meet you at the property and see the property. Then yeah, I'd probably have that sent ahead of time for them to review, make sure they reviewed it, didn't have any questions when you meet them. The buyer acknowledges that after entering to this written agency agreement, agent might request a modification in order to act as a dual or designated agent in a specific transaction. If asked, meaning they don't have to consider right now, but if asked, permission to act as a dual agent will not be considered, or permission to act may be considered at the time. And then same with designated agency. So a couple things on this. With me being the broker in charge of all the local offices, we do have it where if it's a local Keller Williams agent, it does go to it goes to disclose designated agency. By law, it's not technically designated agency because we are technically 5 separate entities as far as the LLR is concerned. That being said, as an abundance of caution, we are still going to disclose it and say, listen, this is because it's the same broker in charge. We're just going to have this as designated agency. You do not have to accept designated or dual agency, right? This says that you may consider it at the time. So if Sarah and I are working together, she's my agent, and I know that she possibly, in one situation, she's going to show me one of Garrett's listings, right? And they're in separate offices. Sarah and Garrett probably don't really know each other. I'm not too concerned about that really being any sort of conflict on there. But if Sarah presents me a situation that says, hey, I'm putting my, my husband's house on the market, right? And I'm going to be representing that, that's probably not a dual agency situation that someone maybe, consider that be fair representation as the buyer when she herself is actually the seller, right? Or if it's a, you know, a close relative or something like that. So again, it doesn't have to be accepted, yet you do want to make sure, because we do have, you know, between the offices, we have close to 400 agents in Charleston. We want to make sure that, hey, that may be considered at the time. The only time that you'll have dual agency is if you are on a team and it is one of your team's transactions, right? Or if you are truly representing the two different clients. Those will really be the only times. The third time, which would, you know, take a miracle, is because I'd have to have a listing, is if I had a listing, then you brought the buyer, right? At that point, it would be dual agency. I would say the same about Lynn. Like if Lynn had the listing and you brought the buyer, again, she doesn't though. So at that point, it would be dual agency. Again, they don't have to agree completely, but they can just say it would be considered at the time. Okay. Paragraph 8, this is again where you disclose the possibility of that there are other potential buyers that have entered a similar agency agreement. So again, if Sarah's talking to me, I'm our buyer. Sarah would say, you know, Joseph, I am working with other buyers that are also looking in this area. So just wanted to let you know there may be an occasion where this, you know, if you put an offer on a house, I'd also be representing a buyer and the other, and that's also looking at this house. Probably not something you'll spend a lot of time on in the initial buyer consultation. However, in the event you do come across this situation where you have two buyers that are offering on the same house, I would not just rely on this one small paragraph in your buyer agency agreement for that disclosure. I think it would be worth going a little above and beyond to say, hey, Sarah, just wanted to let you know, I know we're putting in an offer on this. I also have another buyer that's putting in an offer in it as well. I'm just letting you know in full disclosure. Obviously, I'm not going to disclose to them what your offer is or vice versa to give anybody an advantage. But I do want to make sure, in the abundance of caution, that I'm, you know, just being transparent with you. You rarely in that situation will get anybody to push back. What you don't want to happen is two months later, those two buyers are at a cocktail party and they find out that, you know, you were representing both of them. And they're like, oh, interesting. So she put in an offer that you won, I didn't win. And I didn't even know she was representing both of us. Those are where it comes up to get a little squirrely, if you will. All right, paragraph 9 is what I talked about earlier, the indemnification of the broker. This is where the buyer promises to disclose the broker whether they have signed an agreement with any other broker or has been given prior information about any property subject to his contract. So again, by signing this, you're saying, Mr. Broker, hey, or Mr. Buyer, hey, I'm I'm not working with any other buyers on this, or any brokers on this as well. Paragraph 10, disclosure of the buyer's identity or confidentiality. If you do, there can be a case if you work with a high net worth buyer or happen to work, you know, with a public figure that they may want their identity to be kept confidential. And if that's the case, they just need to understand that if you get into negotiations at some point, you're going to have to disclose at some point in time who you are or your ability to buy if we're going to keep you confidential as a buyer. But if they do want you to be kept confidential, they would have to mark it here that they do not have the buyer's permission to disclose their identity to all property owners and other third parties. Okay. Buyer's liability limitation. So this is one that I say this is a good area to kind of use this as a a benchmark to say, hey, there are other people involved in this transaction other than just you and me, Mr. and Mrs. Buyer. So the broker liability limitation basically says the buyer agrees broker provide buyer with benefit, services, assistance, and value in bringing about this contract. In consideration of the recognition of risk, rewards, compensation, and benefits arising from this transaction, buyer agrees that they shall, well, the first part talks about attorney's fees and everything, shall not be liable to the buyer in the amount exceeding the broker's compensation by reason of any act of omissions, including negligence, misrepresentation, errors in omission, or breach in undertaking, or unintentional or intentional or willful acts. This limitation shall apply regardless of the cause, action, or legal theory asserted against the broker, unless the claim is intentional or willful act. Basically, what this is saying is that the buyer agrees that they will pay the broker's attorney's fees, but they will not be reliable, me being the broker, will not be liable for anything in more than what my compensation would have been. You will possibly get buyers that will push back on this, right? This basically may say at this point, hey, I honestly, if something goes wrong, if you omit something or do something in this and we get sued, I'm not going to hold you harmless to that. Like, I want you to I'm sorry, but I want to sue you. If you get a buyer that pushes back on that, call me. I mean, our attorneys have reviewed this paragraph. They don't think it really makes a difference if they decide to strike it or not. Because at the end of the day, if something gets litigious, it'll get litigious. Buyer will identify and hold harmless and pay attorney's fees for the broker for breach of contract, any negligence or intentional acts by any parties, inspectors, professionals, service providers, contractors, including any introduced or recommended by the broker. Again, this is why it's super important when you're teaming up with other people in the contract that you understand, hey, I'm referring to you, John Crompton, with John Crompton Real Estate Service, inspection services, because I have experience with him. However, you are more than welcome to ask or hire anyone you would like. I've had good experiences with this person, but again, it's completely up to you on there. You just want to make sure that you share that with them. Okay. Paragraph 12 needs to be updated, but basically says buyer and broker will agree that any actions carried out will not, we will not discriminate in any way, shape, or form against any of the federal protected classes. The buyer acknowledges the broker is being retained solely as a real estate agent, not as an attorney, a tax advisor, lender, appraiser, surveyor, structural engineer, home inspector, which is why Mr. and Mrs. Buyer, throughout the transaction, I'm going to introduce you to each one of these people in here so you can get advice directly from them. If you don't have an attorney to talk to, you'll have an attorney that's going to represent you at closing. If you want a referral to a tax advisor, here's someone that I would recommend as a tax advisor. Lender appraisal, all of these people are going to be working together in this. This paragraph 13 really is the ability for you to state at this time, hey, I'm here to facilitate a lot of communications with you and people of importance in this transaction. I am not the end all be all though. Like, make sure you don't position yourself to be the go-to for every bit of advice. And then you're relaying information that, quite frankly, a surveyor or a structural engineer should be talking directly to the buyer about that. Okay. Mediation clause says if there's any dispute in this agreement between the buyer and the broker, that we will go to mediation through NAR before we will sue each other. If the buyer has any questions on any sex offenders or criminal information, the broker is not responsible for obtaining and disclosing the information. So basically, the buyer agrees that they have the sole responsibility to obtain their own sex offender, death, psychological stigma, all the other things that could happen around the house is up and to the buyer to find that out. And then any contingencies you want in here, you can put in there. Most of the time, what we see in there is something along the lines of this buyer's agency agreement only pertains to the Charleston area. Any properties purchased in, say, Hilton Head would not fall under this because they could be working with somebody there. Also, a lot of times where we have the easy out agreement, where anytime either party would like to be released from the contract, they will do so. Fax and other electronic means, as parties basically agree that electronic means works for this as far as communication is concerned. You can use fax machines, but electronic signatures are also accepted in there. Surveillance basically says buyers advise that properties they've entered may have surveillance in there, and the broker, we advise you to be aware of possible surveillance, conduct any and all communications to the potential property offsite. So let's not talk about the property, our ability to purchase the property, anything like that while we're inside the property. It's a legally binding agreement. If you have any questions about it, seek legal counsel. All right, that's the buyer agency agreement. Questions?
Thank you, Joseph.
You're welcome.
I'm good to go.
As many times as you hear it, it's
you.
always good to hear.
It's always, I mean, each time on there, I'd like make little notes. I'm like, I gotta maybe check on this one. So, well, here's the deal. If you have any questions about it, go through, fill one out. If you have any questions, shoot me an email. I'm glad to answer any questions y'all have. All right. Well, if you guys are good with it, we'll have a quick contracts class, 36 minutes. All right, guys. Thank you for everything.
All of the questions are going. I said all of the questions are going to come after.
Right.
After the recording. So.
Yeah, exactly. And then that's just shoot me an email, pick up the phone, and I'll be happy to answer any of them.
Cool beans. Right, thank you.
All right, everybody. Have a great afternoon. Bye.